Lily here to do the One America presentation on N400 trainings, and it's really good. I'm actually confused.
All right, thanks everybody. So my name is Lily Hinkins. I'm the program coordinator at One America for Washington New Americans, which is the program that runs Citizenship Day in partnership with you all. And in just a few minutes, we'll be jumping into an in-depth training of the new version of the N400 that was released on February 4th. Applications filed after May 4th have to be on this new version of the form. So for our Citizenship Day on April 26th, we will be using this new version of the form, and it's going to be the first time that we're using it. And so just wanted to say thank you all for being here or for calling in. Even if you're not volunteering with us this time around, maybe you'll volunteer with us in the future. Either way, I hope that this is useful. If you're here in person, make sure that you sign in on the sign-in sheet and put in your bar number so that you can get CLE credit. And then if you're on the phone, we'll ask that you email Alma to confirm that you attended so that you can get the credit. And I'm going to go ahead and turn it over now to Emily Headings, and she's going to be going into the form and a little bit of the training. And then towards the end of our time together today, I'll be coming back on to go over a little bit about logistics for Citizenship Day and some frequently asked questions. For those of you who are volunteering with us, and then those of you who haven't volunteered in the past, you'll get a better sense of what that commitment looks like and if you're able to do that for us in the future. So thanks for being here.
And basically we're just going to go over the eligibility requirements for citizenship and also refer to the new form, so it'll be helpful to have that handy so you can look at that because we'll be going back and forth. Greg Rogers is going to be joining me hopefully soon here. We tend to do kind of a tag team thing. It's a lot of information, so we sort of split it up, so he'll be joining us in just a bit. So let's just start right away with basic eligibility requirements. Probably most of you are familiar with these. A person has to be at least 18 years old to apply for naturalization. There's certain residency and physical presence requirements. There's a good moral character requirement, which is quite huge and involved. The applicant needs to speak, read, and write basic English, and also have a knowledge of U.S. history and government. And then they also need to be willing to take an oath of allegiance. All right, so probably most of you are aware that there is a new N400 form. It came out in February, and starting on May 5th, USCIS will only accept the new N400. Until then, you can continue to use the old one, which is obviously much shorter. It's only 10 pages compared to the new one, which is 21 now. Just to go over some of the changes on the N400 really briefly, there's the new barcode technology, which is very obvious there at the bottom. It takes up a lot of space. That's what causes the increase in page numbers quite a bit. There's additional fields that are provided for a number of questions. That also increases the length, even though the information required is the same. Part 11 is greatly expanded, and that's related to the Child Soldier Act, and then another law that was passed in 2004. So there's not any change in requirements, it's just the form being updated to reflect those changes from some time ago. There's additional questions about family members and people who prepared the form. There's an interpreter's statement that the prior form didn't have. And then there's some specific questions about renouncing foreign titles that weren't on the old form. And then we'll get in a little bit more. We'll kind of show you where some of those changes take place. All right, so the residence requirements. Actually, how do I make this full screen, Alma? Do you know?
That is full screen.
That is full screen. Okay. Okay, so residence requirements. Obviously, someone needs to have been admitted for lawful permanent residence, and they have to have permanent residence for generally 5 years at least, unless you're married to a U.S. citizen, and then it can be 3 years of residence. It's key that if you're married to a U.S. citizen, you need to be married to that person for the full 3 years, and you need to be living in marital union at the time you apply, even though that's not necessarily required at the time of the interview. In determining the LPR date for refugees and asylees, there's a special rollback rule. For asylees, it's 1 year prior to the date that their adjustment was approved, and for refugees, it's usually rolled back to the date they were admitted to the United States, regardless of when they applied to adjust their status. All right. So looking at the N400, obviously the residency requirement is asked about right up front on page 1. And the first two are, of course, the first two, 1 and 2 are the most common bases for eligibility. And again, a reminder that if you're applying under the 3-year rule, you need to be living with that U.S. citizen spouse at the time you file. All right, and then residents, they go into residence, yes.
Are you going to say anything about whether it makes more sense to do the 3-year or the 5-year if you qualify also for the 5 years later on, or?
Yeah, we'll touch on that in the good moral character portion. Hello, Greg. Glad to see you. So looking at page 3 and 4 of the N400, again, there's more questions about residence, and as compared to the old N400, they break down the information quite a bit more. They give you separate fields for address and putting in the dates where you lived, the dates when you lived at those particular addresses. Something about this form you may notice right away is that if you don't put in full information, it doesn't take the information. For example, if you don't put in a full date, it kind of converts it to a full date. So, you just have to be aware that it's going to change it to 5/1/2010 if you just put in May 2010. Okay, so, all right, here's what I got.
Ready? So the residence requirement, one of the things a lot of people wonder about this is what they mean by it. Do you have to live in the United States the whole time? And so this makes it real clear. This is slide number 7. Absences are the big issue that you're most concerned about when you're talking with people about it, when you're gathering information about their history, and you're really looking at the amount of time you go out on any one particular trip. So an absence of less than 6 months or equal to 6 months, not an issue at all. Anything of greater than 6 months to a year, you start having some generalized concerns. You want to be thoughtful about it and ask them some questions. And an absence of 1 year or more, that breaks the residence issue. And the concern that you really should have is that you don't want to submit an application for a person who has one of these issues where residence is a concern, because potentially they might not only not be get naturalized, but they also might be determined to not be a permanent resident. So you really want to think about that issue and start focusing on it. What was the purpose of your trip? When you left, did you plan to come back? Did you keep bank accounts, loans, things like that? Those are the kind of questions that you're going to look at for this residence issue. Okay.
All right, so another one of the residence requirements is that the individual needs to have resided in the district where they're going to file for at least 3 months before they file the N400. And then also in that same district, or in the U.S., from filing the application to the oath. Generally, that's only about 3 months in this district, so you want to advise people not to leave the country for a significant amount of time after they've filed. You can file as early as 90 days before you complete the residence requirement. So for 5 years, that would be 4 years and 9 months before you actually complete the residence requirement. Or for the 3-year filing, you can apply 2 years and 9 months after having been admitted for lawful permanent residence.
Don't forget on the 3 years, don't file before you've been married to the citizen for 3 years. You have to complete that part of it, but you can be an LPR for a little less than 3 years. So the next one then, we go to the physical presence again. The physical presence, you have to have been physically in the United States for 1/2 of the period that you're talking about, either a 3-year period or a 5-year period, depending on which one you file. And just kind Can I go on to the next one? So on the next one then, this is slide number 10. This shows page 7, part 8. So if you're looking at the N400 form, this is helpful to see. Counting, this is a way to be able to count presents. If you haven't done it before, any time that you're in the United States, either the day you took off for a trip or the day you came back from a trip, the U.S. government will generally consider that to be a day in the United States, so that's something to consider about. The change on the N400 this year with this new form is it only asks for 5 years of travel, and that's different. You used to be able to attach all sorts of extra pages with that information. So what we're kind of planning to do is, you want to ask about that 5 years, you certainly need to have that information, but you want to know generally about the person's travel history and find out more if you can to see if there might be something in that person's time in the 20 years they've been a permanent resident that they might have been out for an extremely long period of time, and you want to have some concern about that. I see a question over there.
Yeah, so because the form changed from listing all the absences during the time of LPR to only 5 years, do we have any indication from CIS whether they are going to be focusing only on those 5 years, or are they still as concerned as ever about, absences 20 years ago?
So the question is, if the CIS is only asking a question about the 5 years, are they sending a message, we're only concerned about these 5 years now, or we're not concerned about any time after that? I think we don't know the answer to that yet, and I think what we've decided as we were putting this together, and we'll see how AILA National does it as they roll out something later on this week as well, is we think it's important as attorneys to find out all about the entire time out and then be able to advise people so that we know whether there's an issue. We are generally hearing that outside that window it seems to be less significant, especially for a person who's traveled in and out quite regularly. Things I've heard from CS, and we also pass messages around to each other as we have a client who's going into this situation, CS seems to, at least in this district, or this field office, say that if you've been admitted back several times, you're still going to be considered a permanent resident, even if something occurred many years in the past. But we think it's safer to get all that information and really go through it all specifically.
Thank you.
Oh, I did, on this, like some of the slides we wanted to make notes of. For here, just remember, if you don't have a specific date, and people often don't, using saying approximate, APPROX, if you want to write that in with the dates. Attaching a statement, something like, since 1990, I've been going to Mexico for approximately 1 month every year. Put that kind of information in there. Understand that these new pages, at the bottom of every page of the new N400, there's a barcode information. And when you're typing on a computer, the information that's printed on that particular page is encoded in the barcode information. So if you're changing things on that page, there's going to be a bit of a discrepancy between what CIS gets when they read the barcode and what is on the actual form itself. So you want to be sure to flag any additions or changes because they will be different than what is on the barcode. Not moving.
Hey, Greg.
Okay. Yes, Chris.
Can I just raise a situation which I think is instructive in terms of the question of residence, maintaining residence. I know you kind of jumped past it already, but
Sure. A question about residence.
a question came up this morning where somebody had gone out of the country to attend to a sick mother, and the mother got very ill, and now it's been like 13 months, right? So flags go up, warning flags go up. Assuming that the person's able to come back without any problems, then clearly they're restarting the 5 years, right? Because they've gone over 1 year. Is that right?
Yeah, that's we're breaking actually 6 months breaks.
Yeah, so the 1 year is the automatic break, right? That's for sure. 6 months to a year, it's a rebuttable presumption that they didn't break continuous residence. I guess you could still ostensibly have the abandonment issue, but it sounds
Right.
like from the facts that wouldn't be.
So just to be sure of the question for the people who weren't able to hear that, the question was a person who went out to take care of his sick mother, was out of the country for 13 months, was able to actually get back in either through at the consulate in SB1 or coming back they're still considered a permanent resident, but there might be a break in the continuity of residence that happens to reestablish the period of time. There's another question.
Can you clarify again whether the day of travel and the day of return are how they're counted?
The question is, how do you count the day of travel and the day of return? You can count those as days in the United States, specifically in the United States. Right.
So can you say a little bit more about that, how they're using this barcode? I mean, normally now when we go in, they've got the paper copy, and are they, you expect the practice? And I suppose that could be significant in some cases where you make a notation on the form that doesn't show up on the barcode, and if they make allegations about fraud or something like that. Do you have
So do you have a particular, the question is, talk a little bit more about the 2D barcode that's on the page there and what might happen if there are changes between what's typed and what's written and then what actually happens at the interview? Did you have?
Well, I was just going to say, I think that's a real concern because, yeah, what is going to be populated into that form is going to be different perhaps than what the client actually wants to say. So I would say we need to be a little more proactive in interviews when we're representing a client and making sure they have the correct information on the form, even if it's not captured by the barcode technology.
And I was on a CIS call where they talked about the 2D barcode for the G28s, and they were talking about that as they roll it out. And one thing they said was because of these distinctions, it would always be best if you're having changes to put some sort of page on top of it or some sort of flag that says information in page 13 has been changed, is different than what's on the barcode. Something like that so you can actually point that out. And the adjudicator, I think, would have that information then at the interview.
All right, so one additional requirement is that the applicants speak, read, and write some basic English. Speaking ability is determined at the interview, answering questions about their application. The applicant's given a couple of sentences to read and write, and they'll have been provided with the vocabulary for these sentences beforehand, so they can study. They say the English level is at about a 4th grade level. There are some exemptions to the English requirements. We call them the 50-20 and the 55-15 rule. If individuals are at least 50 years old on the date of filing and have been lawful permanent residents for at least 20 years, then the English requirement, speaking, reading, and writing, is waived. They still need to take the history test in their language. Same for people who are 55 years of age or older on the day of filing and have been a resident for at least 15 years. Folks that are older than 65 years can take a reduced test. That means they only need to study 20 questions instead of 100. And then, of course, they also qualify for the English waiver. And then there's also disability waivers for individuals who have medical conditions that prevent them from learning or remembering information, and that's something that a medical provider needs to help with. We need to get them to fill out the disability waiver form. And that's not something we would work with at Citizenship Day, but you may see them in your practice.
So the history in civics is a different one than the English language. This is slide number 12. I encourage you all to go out, if you haven't done it already, go out and look at those. The kind of questions there. You have to get 6 out of 10 questions correct. The government gives you the 100 sample questions. There they are. They give you the answers. So there's all sorts of study guides to be able to test up for this. If you're talking to a client how this works, they're sitting there and then just kind of notice that the person who's doing the interview, something popped up on the computer screen, and those are the 10 questions. If they get the first 6 right, they won't hear 4 more questions because they're done. They've satisfied that requirement. Remember, though, on the right-hand side of the slide, though, if the person at the time of filing was 65 years old or older and a permanent resident for 20 years on that date of filing, they can be exempted from the English test, and they can also be tested in their native language, and they get a smaller group of questions. So you only have to study 20 to get 10 out of the 10 questions. And there's a disability waiver as well for that.
Okay, just a bit more about the disability waivers. NERP handles a lot of these type of cases. The disability waivers can exempt someone from either the English requirements or the history requirements or both. It needs to be based on a medically determinable physical, developmental, or mental disability that at least lasts for a year. And the standard is that the person needs to be unable to learn U.S. history and civics. Not that it's difficult or really hard. but that they are unable to learn because of their disability, which could be something like dementia or a stroke or depression, post-traumatic stress disorder, a whole variety of things. Anything a doctor would determine is prevents the person from learning. And the individuals qualified to complete the form are medical doctors, doctors of osteopathy, and clinical psychologists. If the person's primary care provider is a nurse practitioner or some other professional, they won't be able to sign off on the form, although they could complete the form and have a doctor sign it.
And the wonderful thing about slide number 14 is these questions 11 and 12 that the government has on here actually help us make sure we're dealing with this question on the material that we gather. So that asks, do you have this disability? Or number 12, exemptions from English language. So it's right there on the form. It's a question that's asked, and you're kind of forced to go into it and help your client decide, is this something we want to ask for or not? There's a question in the back.
So at Citizenship Day, we get a lot of clients who are illiterate, not only in English, but in their native languages as well. And so, if I remember correctly, the 55-20, or 15-20, 55-15 rule exempts them from needing to prove literacy, or does it not?
Right. So, yeah, the question was if an applicant's illiterate, do they qualify for one of the exemptions?
Or
right?
If they already qualify for one of the exemptions, does that mean they don't have to do the writing portion?
Right. So if someone's illiterate and they qualify for one of the exemptions under what we're calling the 50-20, 55-15 rules, then right, they don't have to show reading and writing ability in English. The fact that they're illiterate is irrelevant if they qualify for the exemption.
But otherwise, they need to.
But they still have to take the test in their own language.
Right.
So,
yes. Yeah.
But that's
so
verbal?
It's just the English that they're
Right.
exempt from. They still have to take the oral history test with the help of an interpreter.
Okay.
And they should bring in their own interpreter, right?
Yeah, generally. Although you can ask for interpreters on the phone if you don't have your own interpreter. There's pros and cons to that. Okay, and then the final requirement is that the applicant needs to be willing to take the oath of allegiance, and it's notable that they need to be willing to bear arms. If they have a religious or philosophical belief that prevents them from carrying weapons or fighting, they can ask for that, usually just with a letter from their religious organization, or sometimes just a statement about their philosophical beliefs. And under the oath, under the portion of the N400 that has the oath questions, a new question has to do with giving up titles of nobility. So they're just making it a little more explicit on the form that when you take the oath, you're giving up any inherited title or ordered nobility that you had in another country.
All right, we're going to go in. Goodness, I still I'm trying to figure out how to switch the slides on this computer here. So now we go into one of the next major issues that you have to be able to establish that the person is a person of good moral character during the statutory period that you're talking about. So it's either a 3-year period of time or a 5-year period of time. There are statutory bars and there are discretionary bars, and we're going to spend a whole bunch of slides talking about these ones as they come up. So I'm going to take the next one.
Okay, so generally in doing the screening for good moral character, we'd say there's 3 steps you might want to go through. First, you're looking at is, because of the person's conduct or whatever act you're looking at, are they barred from establishing good moral character? We'll talk about what that means. Second, you want to look at, could they, even if they're not outright barred, could they be denied because of, some bad conduct that USCIS considers in their exercise of discretion? And then finally, you want to make sure that they're not removable because of the conviction or behavior that you're looking at. So there's kind of 3 steps you want to go through when you're looking at criminal records or whatever the conduct is at issue.
Slide number 18 gives you at the base of it the INA information about good moral character. And it's important, sometimes you hear about this, someone's got a situation and something happens between the time you file and the date of the interview. there's some issues there as well. So remember this as to go from the prior to the filing through the period of the ceremony, that 3 or 5 year window of time that they're looking at. But as the second bullet points out, if the person does show good moral character during the statutory period of time, that there's not an outright bar to naturalization based just on those issues. It's something, some of those things can be considered, but it's not an outright bar. And they'll look at all the issues associated with good moral character potentially as they go through it.
All right, so when thinking about good moral character, we think about permanent bars and temporary bars. The temporary bars are generally the ones listed in 101F that once they move out of that 3 or 5 year period, they're not bars to showing good moral character. So the permanent bars, which are in the statute, are if someone's been convicted of an aggravated felony after November 29, 1990, that means they can never be eligible for naturalization. And then secondly, if they've been convicted of murder at any time. So that one's not time related or time connected, but prevents someone from showing good moral character for naturalization. I believe there's another permanent bar that has to do with deserting the military during times of war.
All right, so let's start talking about what are the mandatory bars for being naturalized based on good, not having good moral character. Again, the two big ones that are always there: conviction for murder at any time. I don't know. Maybe people in the room have had people who've got a conviction of murder who are interested in naturalization, and also ag felony. And remember, for the newer members, aggravated felony is an immigration term. It's not just the standard criminal justice term. But if you don't have those two that are the mandatory bars, let's look at the statute. Within the statutory, these are temporary bars, but they're still mandatory issues. Being an habitual drunkard, this is a medical diagnosis. You need to have more than just someone says they have drunk. Illegal gambling, 2 or more gambling offenses, false testimony to obtain an immigration benefit of some sort. So these are the first 4 that are on that list, and we'll just keep going. There we go, all right. Then the next one, this is slide number 21. Confinement to a penal institution following a conviction for an aggregate period of 180 or more days. Number 6, conviction or admission to a crime involving moral turpitude. And the admission issue is something we're going to go over in just a little bit. There's a thing called the petty offense exception. 1 CIMT, possible sentence is a year, sentence to 180 days or less. That's the petty offense exception. And then conviction or admission. Substance abuse is a big one. On admissions of substance abuse, we're starting to hear some stories now in the Customs and Border Liaison Committee on national level that some CBP officers are just taking it upon themselves to ask people coming into Washington and Colorado, do you smoke marijuana? How often have you smoked marijuana? Have you ever held it and possessed it yourself? And then go through a whole series of issues about that. So this issue about admission, you might not have ever been convicted of it, but if there's something written there, there's potentially a reason for concern. And then the number 8 one is conviction, 2 or more offenses with an aggregate sentence that's actually imposed of 5 years or more. And yes, good. Number 9, reason to believe drug trafficker, not just a possessor, engaged in prostitution. Again, these are people who are either prostitutes or they pimps, not a person who's engaging in the services necessarily of one. Alien smuggler. Alien smuggler, remember, can include issues about taking children across borders, things like that. So it's something to be cautious of when you're talking with people with families who aren't already permanent residents. And then coming into the U.S. to practice polygamy, and I don't think many people have had that issue, although it certainly could be one. And there we go.
All right, so in looking at these, often you're looking at, is it a conviction, is it an admission? So you want to make sure you know what a conviction is. Many of you know it's defined in immigration law. 2 points, the judge or the jury found the alien guilty, or the immigrant pled guilty, or admitted sufficient facts to warrant a finding of guilt. And then in addition to that, the judge ordered some punishment or penalty or restraint on liberty. So you need both those things to have a conviction. In some cases, you'll see that the case was dismissed, there was deferred prosecution, there was a stipulated order of continuance, and the applicant may think, oh, that was all taken care of, it was dismissed, but you need to be careful about whether there's a conviction underlying that dismissal or diversion, or just check and see if it fits the definition of conviction, because you don't want to send anyone in with a conviction that they thought was all taken care of.
All right, going on to slide number 24. So the question is what your client's done an admission? And there are the 4 formal steps for it. Admitted conduct that constitutes the essential elements of a crime. Again, this number 2, provided with the definition and the essential elements of the offense. 3, admission is voluntary. 4, admits to all facts constituting the crime. Again, on this issue, issues that constitute the essential elements. You've read any of those CBP notes on the board, you'll see people, the officers ticking through a whole series of things, and they're looking at the essential elements of crime to be able to get that documented.
And you guys, can you make sure the people on the phone are having a bit of a hard time hearing unless we're speaking right into the microphone?
Thank you very much. Did someone have a question?
I do.
Michelle.
So, looking at your the PowerPoint, the mandatory bars to the moral character at any time a conviction, murder, or aggravated felony, but then just within the statutory period of time, the numbers 1 through 12.
Right.
So if somebody has any of these other ones at any time outside the statutory period, would it recommend it to file?
Okay, so the question was, looking at 1 through 12 that Greg just went over, the question was if those acts or conduct are outside the 3 or 5 year statutory period, which is required for good moral character, do you advise people to go ahead and apply? Is that right? Mm-hmm. The question. So once they're outside the statutory period, so immigration isn't supposed to look outside the statutory period unless you still have some bad conduct within the statutory period, and then they can sort of consider, well, did the person reform? Are they now a person of good moral character? They can kind of consider that in weighing the good and the bad, okay? But they shouldn't be absolute bars once they're outside of that 5-year period.
So if they have been model citizens within the statutory period, but then they have one of these other things like reason to believe a drug trafficker, they could be naturalized, or?
Well, they could be eligible for naturalization, but still deportable, right? So that's sort of, that's step 3 in that 3-part analysis. So yeah, arguably they'd be eligible for naturalization, but they could still be referred to proceedings for reasons of belief. Karen?
So the one with the statutory bars, 180 days plus in a penal institution. So does that include, I assume it doesn't include a civil immigration detention? Let's say you have an LPR who commits something that the state sentences them for 7 days or a month, and then they're put into mandatory detention to resolve their immigration dispute. So and they languish there for quite a bit of time. Does that time in immigration detention count?
Fall under that ground. Okay, so the question was whether time spent in a detention center, a civil detention center, count towards the 180 days in a penal institution, I think is the language. I would say no, because it's resulting from a criminal conviction, but
I would argue no too, because they always tell us that it's civil detention, it's not punishment.
right, it's not a penal institution, which is what 101F says. So I would say no, that doesn't count, but does anyone else have a think otherwise?
So we'll go to the next slide. What are not crimes involving moral turpitude? There's a whole series of things that we've got on the next 2 slides. This is starting at slide number 25. A simple DUI, a simple assault, assault 3 under the RCWs. And obviously, if you're dealing with a person who has been living in multiple states, you want to check the codes for the state that they're involved in. Criminal trespass, traffic offenses. That's driving without insurance, driving without a license, things like that, and certain theft offenses, that are noted here in number 6. And we'll go, oh, there we go.
Okay. So this next slide just lists a couple of examples of things that probably are crimes involving moral turpitude. Generally, theft offenses are, although, you know, we're saying they are not in Washington State, especially after the recent Supreme Court decisions about the categorical approach. Offenses where intent to defraud is an element. Those are seen to be CIMTs generally. Felony assault with particular mens rea above negligence and an aggravating factor. Solicitation of prostitution recently has been found to be a CIMT in the Ninth Circuit. And then also a DUI, when the person had knowledge that their driver's license was suspended, that has been found to be a CIMT in the Ninth Circuit. And then of course there's many more. This is just some representative examples.
All right, regulatory factors now. This is slide number 27. We're dealing with good moral character issues here, and we're looking at time period issues here, so it deals only with acts that are within the statutory period that you're talking about. Again, you can start seeing, for those of you who haven't done it, if you have a person who has one of these issues 4 years out and they qualify for both a 3-year filing and a 5-year filing, you're going to want to use the 3-year filing because you can get this issue outside of that statutory period. Here, number 1, I think, is one of the ones you'll see most often, willfully fail to support dependents, because a lot of the questions that are on the naturalization filing, you talk about tax returns, ask about all different marriages, how many children you have, things like that, because they're looking to see, has this person potentially failed to support their family. Extramarital affairs that destroyed an existing marriage. I actually had a case that involved that a little bit. Committed all unlawful acts that adversely reflect on good moral character, which is a pretty big catch-all phrase there. And then also failure to pay income taxes. Again, file or pay income taxes. That's, again, one of the questions that's asked. Have you paid your taxes? Have you filed your taxes? If a person is on a tax payment plan that they already agreed with the Internal Revenue Service and they're paying that back, that's acceptable. That's not a problem. But they have to have that in place as they go into it.
And I would actually just add that under this catch-all, I've had cases where the person failed to pay off traffic tickets or court fines, even though everything else was taken care of in the case. They found that to show a lack of good moral character. So it's probably a good idea to recommend that the person pay off outstanding fines, not just income taxes, before they apply. Other factors in the regulations that may be considered in good moral character, if someone didn't register for the Selective service when they were required to, between the ages of 18 and 26. And just note that this applies to men who are between the ages of 26 and 31 because the failure to register would have been in the last 5 years if they fall in that age range. A person who's made a false claim to citizenship or voted unlawfully, that could be something that prevents you from showing good moral character, although it's not an outright bar. And then, as we noted here, it's also a potential ground of deportation as well. Probation and parole, if someone's on probation or parole during the 5 years or 3 years, that doesn't mean they can't naturalize, but they do need to be finished with that probation or parole by the time their interview comes around, by the time they naturalize.
All right, selective service is one of the ones that if you're talking with a male and they're going through the process, it's something you're going to be checking on. It's something we have the capability of doing at the Citizenship Day programs. But basically, all males who are ages 18 through 25 are required to register except non-immigrants. And a lot of people just simply don't realize that issue. So this can be a consideration of the good moral character if they hadn't registered. We have access, you can always access registration issues at the website noted there on slide number 29. And even if the person failed to register, and even if it's not outside that 5-year window of time, which takes the person from 26 through 31, or through 30, there are ways you can deal with this issue to show that it was not a willful failure to register. But there's a process you want to go through. There's the status letter. You can also have the person sign an affidavit or a statement showing that they didn't know about it and they didn't willfully fail to register, and that they can do the registration. And we have information at Citizenship days are short, so.
And just to note that getting that status information letter is kind of a new requirement, I guess, on the new form. We weren't required to get that before. All right, voting and
I'm
false.
sorry, you said the
yes,
status
please.
information form, but that's only if you are within that 5-year period, right?
That's right.
Not
That's
if
right.
you're
you are-
outside, you don't need to get the form.
That's right. If you fail to file and you're between the ages 26 and 31, so you can't file any longer, then you would get this status information letter, which, to be honest, we don't really know what that looks like.
Yeah, so Craig, you're saying, should I get it if the person's beyond that period of
No,
time?
I'm saying that the form reads like you need to get it, but actually you don't need to get it, right, as long as the person's past 31.
Arguably, if they're past the age of 31, you don't need to get it.
Right.
And then we even kind of went online to try to find whether we could get into it. I think it was a bit of a problem.
Actually, at the last liaison meeting with CIS, I asked those 2 questions, and at the Seattle field office, they were very clear. Past 31, it is, as they say, in the rear view mirror, we don't care, don't worry about it. And for the 26 to 31, they said that they need that letter because the affidavit alone is not enough, because somebody may claim that they didn't know, but Secret Service, Selective Service, maybe also Secret Service, have information that they sent them, like notices or whatever.
Okay,
That's
so-
why,
Has anyone ever tried to get one? How long do they take?
it took like 2 months.
Okay.
I did it probably 2 years ago, it was a verification.
So just to repeat what someone said here in the room was that the USCIS, the local office, has clearly said they don't need a letter after age 30.
31.
Once they're 31 or older, right? Okay. Oh, and there was a question about how long it took to obtain those status information letters, and Karen said 2 months is what it took her when she obtained one.
Just another reminder to speak into the microphone, and to repeat questions when they're asked.
Okay. All right, so another factor that can be considered, we alluded to this a few minutes ago, either unlawful voting or making a false claim to U.S. citizenship. This is in 101F, but it's not an automatic bar to showing good moral character if you did either of these things within the statutory period. There is an exception for kids whose parents were either U.S. citizens, or who were U.S. citizens. The child became a lawful permanent resident before age 16, and they reasonably believed that they were a citizen because of their parents' status and how long they've been here. And so if they, made a false representation or voted, they can still show good moral character. They fall into that exception. If someone's been convicted of unlawful voting, this could be a CIMT, so that would be an outright bar to good moral character if it happened in the 5 or 3 years. And then there is a good memo on handling naturalization applicants who voted unlawfully, and we've got the AILA document number there. Generally, it says, it kind of walks through the process that the USCIS officers to go through in figuring out if the unlawful voting or the false claim to U.S. citizenship should be held against the applicant. And it has some good language about if the person made a good faith mistake, essentially, then it shouldn't be cause for finding them to lack good moral character.
Okay, we're going to go to slide number 31 now, and this is the beginning, this is page 13 of the M400, part 11. And this is the beginning of a whole new series of questions. It goes on for something like 6 different pages with lots and lots of stuff there. And it's definitely something to pay attention to if this is the first time you've seen this form. On page 13, there, okay. Page 13, number 3, questions 1 through 3 talk about the false claims and voting issues. These are new questions, but they do not change the law. The law is still the same laws that existed before, and any yes answer requires an explanation to be able to use. Number 7, if you look there, this is an interesting one. You really need to pay attention to this one. Have you ever not filed a federal tax, state, or local tax return since becoming a permanent resident? And it doesn't, basically, there are a lot of people who are not required to file federal tax returns. And so the answering yes on that question is going to require some explanation. What we're suggesting as a concept to think about is, a person would answer yes, and then on the attachment they'd say, I did not file a tax return because my income was below the legally required threshold, something like that. So you realize that a yes answer will not necessarily be a problem for you, but you need to provide some sort of explanation. And it's also important to note, because you've got so many new questions on this form, there are probably going to be a fair number of questions that you're simply not required to answer. You don't need to make sure that every single box is ticked down there, because there will be many that say, if yes, then answer these questions, or if no, answer these questions. So there will be some places where there will be blanks left on the form. Make sure there's a reason for them being blank, and then you can leave it that way.
Okay, and then there's a lot of new questions, as Greg mentioned, in Part 11 relating to national security concerns and the Child Soldier Act, and they're broken down into all these subparts. So, if you're working with an interpreter and doing this section, it could take quite a bit more time than you've had to take before. So just because you answered yes to one of these questions doesn't mean that you're not going to be able to be eligible or to show good moral character, but it could mean you're going to have to explain, for example, that you were involved in military training in your country, or that you were in a self-defense unit in your country, and provide a little bit of extra information. So just keep in mind your client's cultural and historical background when going over these questions, and the fact that a yes answer isn't necessarily problematic.
Just to highlight the question about were you ever involved in any way with torture, genocide, and that the guidance as of now is that victims have to answer affirmatively and attach an explanation. So if you want to just say that in the microphone.
Oh, so someone was just mentioning that the question about if you've ever been involved with torture, this could mean involved as a victim as well, so it's not just the perpetrator of torture. If you're a victim of that, you'd want to answer yes and then provide an explanation. Yeah, and then page 15 continues on questions about recruitment and selling weapons and that kind of thing.
So we're going on to slide number 34. Again, this is this continuation of many more questions where there used to be just a few, and it was all put together, and you just answered no or yes, and now it's broken down very, very specifically. So if you look at questions, oops, we're on slide number 30. It's 32? Slides are long. Yeah. Hold on 1 second. Ah. Great. So if you look at questions number 22 through 28, especially have you ever, number 27 and 28, have you ever received a suspended sentence, placed on probation, or been paroled? Have you ever been in jail or prison? Ever been in jail or prison? Probably some of you have been in jail or prison, but not necessarily incarcerated there. So to answer questions to these, it's better to answer, arguably better to answer yes and provide an explanation than to leave it potentially incorrect and not have a full explanation there. So certainly the jail or prison is the time that someone's incarcerated though.
Oh, and another thing just to point out, questions 22 and 24, they also added, have you ever assisted in committing offenses or attempted to commit? So just kind of expanded the question. It's helpful to break it down when you're actually asking the applicant. All right, so there is a section where it asks about arrests, and on this section, page 16, part 11, you're to include all arrests, charges, convictions, including traffic tickets, because it asks for citations as well. You can let the applicants know that USCIS will learn about your conviction or arrest history through fingerprinting and whatever other types of background checks they do. Before applying, the applicant should obtain all their court records and have them reviewed by someone who can do that analysis. And again, when someone's on probation, they can't NATS, but just because they're on probation during the statutory period doesn't mean they can't show good moral character.
So here, this slide number 36 has two great references to be able to get information. When you're always going to want to check out the person's criminal record. I think it's a really important thing to do, even if they tell you no, that they don't have any record. A lot of people just fail, they might have been told at some point in time in their lives, this record's been expunged or purged or something like that. You don't have to tell anybody about it. They hear that and then they just think it never occurred. So you do want to check on those and those youthful indiscretions that someone might have had. It's always helpful to get it. So the FBI record and also the state criminal records, and there's two sources there. Keep those available, and they're quick and easy to get information about.
All right, so generally when you are reviewing someone's history, you're going to want to look at their record of conviction, if they have any such convictions. You're going to want the disposition, whether that was a dismissal or a judgment, the charging document or a plea agreement, if that's applicable. If the incident was something that happened within the last 5 years, you're probably going to want to get the police reports because those are sometimes requested. And generally, I like to argue that if it was outside the statutory period, you don't need to submit police reports, and I wouldn't, I guess, submit those at any time unless they were requested. But outside of the 5-year period, I would argue that they don't need to be submitted at all. And there is an old Legacy INS memo that sort of talks about that and not needing police reports outside of the 5-year period.
Yeah, those police reports can have all sorts of strange information in it. It's always a danger to consider using a police report unless you're absolutely required to do. So slide number 38, we're back to the selective service information. Again, they get very focused on this ages 18 through 25, the 26th birthday, so it's a different period, and you're looking at the window there. And if you look at number C, and did not register, this status information letter, again, it's this new absolute requirement here. So basically the point is, if you did not register and you're between the ages of 26 and 31, then you must include that status information letter and your statement, your affidavit or something saying I didn't know, didn't realize, I didn't do it willfully, and you want to request a letter. The general consensus seems to be right now that you'll probably be able to file without this letter. We've heard that it takes up to about 2 months or so to get. 2 months would be enough time to be able to get that letter before your examination is scheduled, but you're going to at least be required to have that at the examination itself. So if you don't already have it, and the person who wants to file should be able to do it, but you need to make sure they actually do get that letter before the interview.
All right, so just a couple of practice tips to sum up the good moral character section. When you're looking at the person's history, look at the date of the violation of the offense, not the date of the final court disposition. That could help someone out if something falls out, the actual offense fell outside the 5-year period. If it's possible, apply under the 3-year rule if they're married to a U.S. citizen, and that's a shorter period of time that's required for good moral character. If it's not something that's an absolute bar but could be held against them in the exercise of discretion, you might want to just wait until that act is outside the 3 or 5-year period. And then again, make sure you get certified copies of all court records because that's what immigration will request, and don't send in sealed police reports. Yeah. Okay, so something you always keep in the back of your mind when you're looking at someone's immigration history is the person also removable? Applying for citizenship gives USCIS an opportunity to review their entire file and history, and something may come to light that was something that actually makes them removable. So you want to make sure you've done that screening and make sure you're not getting someone into trouble. And again, they may be removable or deportable, but they may have some sort of relief in removal proceedings, and so that may be kind of a way to argue that they should be able to be natsed even if they potentially have a removable offense on their record. And then just listing a couple of forms of relief here: cancellation, 212C, 212H waiver, etc. It's also possible sometimes to ask that the immigration judge terminate proceedings so that someone can continue on with a pending naturalization application. That can be a little bit tricky because you often need DHS or ICE to say, or USCIS, sorry, to say that they're prima facie eligible for NATs, and I'm actually not sure how easy it is to get them to agree to do that when someone's been referred to proceedings. So just something to keep in the back of your mind. Okay, so we have a couple slides that look at removal grounds. As many of you know, there's one big ground of removal called an aggravated felony, which is quite problematic, and I think we have an incorrect citation here. It should be 101A43. But then this slide just lists various crimes that could be, that are aggravated felonies under immigration law. Crime of violence plus a 1-year sentence, a theft offense with a 1-year sentence, firearms trafficking, a crime of fraud or deceit where the loss was over $10,000 to the victim, and many more that are there in 101A43. As I mentioned before, making a false claim to U.S. citizenship and unlawful voting can also be a basis for removal, even if they're not absolute bars to good moral character. You don't necessarily need a conviction even for it to be a ground of removal. Note that the false claim is time limited, so it's only those claims made after September 30, 1996. And the false claim needs to have been made to get some sort of benefit under state or federal law. In the unlawful voting, for it to be a deportation ground, also look at the mens rea, or the mental state that was required to violate that law. Some, especially state or local voting laws, have a knowing requirement or a willful requirement, and maybe the person didn't meet that requirement. And then there's a good case in the Ninth Circuit that talks about that issue. All right, and then the next slide, 43, just lists some other grounds of removal. You know, if you don't do removal work, typically it'd be good to just have these in the back of your head when you're looking at a citizenship application at Citizenship Day, for example. Conviction of a crime involving moral turpitude within the first 5 years of admission, if the crime has a possible sentence of 1 year or more. So that's in Washington State greater than a gross misdemeanor now. Certain firearms convictions can be problematic even if they're very old. If someone has 2 crimes involving moral turpitude after they were admitted, even if they're very old, that could be a basis of removal. Controlled substance convictions, there's an exception for simple possession of marijuana, 30 grams or less. And again, even though it's legal in Washington State, it's not federally, so keep that in mind. Violation of a DV protection order also is a ground of removal, and this is something that wouldn't necessarily show up in the watch or the Washington courts check that Greg had talked about earlier. A couple more grounds of removal on the next slide, 44, conviction of a crime of DV after September 30, 1996. That requires 2 things. It has to be against a protected person and also be a crime of violence, which is described elsewhere in immigration law. If they were inadmissible at the time of their last admission, if they're a drug abuser or addict, again, that doesn't require conviction, just conduct that may come to light somehow. And then alien smuggling is also a ground of removal. Just to point out about alien smuggling, if they were convicted of that, then that's an aggravated felony, which would then be a permanent bar to citizenship. But if they just admit to alien smuggling, helping their son or daughter, sending them money, paying the coyote afterwards, then that can still be a problem. Although there is a waiver for certain permanent residents. Still think that exists. Okay. Go ahead.
So slide number 45, the marital history. These are some additional questions that have been added to the form on page 8, part 9, that were not part of the previous form. Oddly, you'll see they even include asking about the current spouse's present employer, which is interesting. Apparently, these questions are being used by the Immigration Service to determine whether the marriage was based on lawful permanent residence is valid, whether the applicant qualifies under the 3-year rule. You want to be thoughtful as you're looking at this one about issues about undocumented spouses, because a person does have to be honest and accurate and truthful when they answer these questions, but that information could come out. And it's important to make sure that the dates of these prior marriages and divorces match up in terms of when a person got married. You don't want to have an issue with the person who's married to one person and when they married the second one. And then multiple short marriages, if you just see this series of things, there's also potentially an issue there with the person bringing in people over and over again as part of the process. So do be aware of these things. And down at G, down there at the bottom, it's the current spouse's present employer. Which again, I think it's just an interesting question. I'm wondering where they're going with that.
All right, so two other new questions that I think Greg just alluded to. Page 16, part 11, question 30 has a bunch of subparts, and they added a question about whether you've ever married someone in order to obtain an immigration benefit. So of course that's something that could land the applicant in removal proceedings. And then the second new question is have you ever made any misrepresentation to obtain a public benefit in the United States? So of course, just getting public benefits should not be an issue for good moral character or eligibility, but if you obtain them by fraud or misrepresentation, then that could be an issue of good moral character.
For that number 30E, are we reading that to mean that if you married somebody principally for the immigration benefit?
So just reading the question was, are we reading 30E to mean if you married someone principally to obtain an immigration benefit?
Or solely?
I would say, the way I talk to my clients is this, that if the fact of your love for each other resulted in you getting a benefit at an extremely important time in your life, that's a side benefit to your love and marriage, and it's not to get as the number one element of your marriage an immigration benefit. Some people marry not because of love, but they might, one person might be pregnant, there might be a child on the way, they want the child to have married parents. And so there are other issues there, but if getting an immigration benefit beats everything else out in terms of the list of all the things for getting married, then you've got a bit of an issue. That's the way I look at it.
So you would read it as principally?
Principally, that's the way I would look at it, as principally and primarily.
What are you thinking about that in terms of asking the question? Because that's not really the legal standard, right? It's the legal standard for marriage fraud is solely for,
yeah, and as Bob points out, the statute is solely to get an immigration benefit. So I start off with that kind of question and then go through a whole series of things. But if it's solely, that's the issue, yes.
And there's also case law that specifically says that if, there was any other reason besides that green card that you got married, it's not immigration fraud.
Comment, there's also case law that says if there's any other benefit that was part of the reason for getting it, then an immigration benefit is not the reason for marriage.
If you wanted a green card and you like her cooking, then you're good to go.
How did you say? If you wanted a green card and what was that?
You liked her
Like
cooking.
her cooking.
And you like her cooking, then you're good to go.
All right, so page 16, part 11, questions 30 to 36. These are just about relating to removal proceedings or prior deportations. I don't think there's anything new in this section. But just note that they're important questions. And since they're multi-part, it's a good idea to ask them multiple ways.
Slide number 48 is acquired citizenship. It's always helpful. It happens probably once a year during Citizenship Day things. It's always great when you're in an office talking to somebody, asking them the questions. Always be sure to talk to that applicant about U.S. citizen parents, grandparents, and go through the historical reference, go through the grids that are provided in so many sources. Look at the derivative citizenship charts, which you should have available to you quickly and easily. It does happen on occasion, and it's a lot better than filing an N-400 and having the person go through the process that way. So if they're already a citizen, keep them from filing for naturalization.
And there is there are now questions on the new N-400 related to this issue to sort of figure out if someone acquired or derived citizenship from their parents. It's a little unclear to me why that was included, just because doesn't mean they're going to issue them a certificate of citizenship and tell them they don't need to do the N-600 now, or what. But there is a new section for providing information about your parents if they were U.S. citizens.
That's exactly what slide number 50, the Child Citizenship Act. You have a client coming in, they have kids, one or both are naturalizing. You want to think about saving them some money, not having the kids file for naturalization. It's not worth it because children are automatically citizens if the conditions are met under the Child Citizenship Act, which is the child has to be under 18. At least one parent has to go through the naturalization process. The child has to be residing in physical and legal custody of the citizen parent, and the child has to be a permanent resident at that time. So those things automatically, when the parent naturalizes, the child is also a citizen as a result of that.
All right, and the new form also has expanded spaces for providing information about your children. It's mostly formatting changes, but it is helpful that in the instructions they kind of lay out who they want you to include in your children. Ones who are alive, missing, deceased, born in the U.S., born in other countries, stepchildren, legally adopted children. So that, I think that extra instruction is probably helpful.
And on that one, I think it's, when you're talking with maybe a couple that's going through the process as well, it's also always helpful to separate them to talk about it, because sometimes there are children that are born out of wedlock and that the other spouse may not know about. It's important to remember that these things all have to be reported, and I'm really glad they asked questions about all children and added all the definitions, because I think that really helps. If we go to slide number 52, other things. We've completed this form just so you see for Citizenship Day to show that there's a process that we go through where if you're participating in that, you are asked to sign your name, if you're in a firm, your firm's name, the full address of your business, and for Citizenship Day you can actually put Iowa CD for Citizenship Day, and then the city in which you're completing that form. But we have been asked to complete that information with our own personal information as well.
All right, and the last new thing on the form, now there is an interpreter statement on page 19 and 20 of the N-100. And it says you only need to complete this if you are asking for an exemption from the English requirement or a disability waiver, and you use an interpreter to complete the form. So you wouldn't necessarily need to complete this if you use an interpreter to clarify a couple of questions, or if you don't ask for a disability waiver or an exemption. But that is just another new piece to be aware of on the form. And with that, we'll have Lily come up and talk a little bit about Citizenship Day logistics. But I guess we should just open it up to any questions either on the phone or in the room that people have about eligibility or the new N-400. I don't think any of us have been in an interview yet where the new N-400 was adjudicated, but I'll answer.
All guests have been unmuted.
Okay, so anybody on the phone have questions related to the new form or to the legal requirements for eligibility?
How can I use my telephone?
Yeah.
I may ask a question?
Okay, go ahead.
Yeah, so it has to do with the alien smuggling issue.
Okay.
So if an applicant has a young child that they brought in more than 5 years ago, let's say at age 3, and that child's now 12 years old, and the purpose of becoming a citizen is to immediately try to get them LPR status, is the applicant at a huge risk of being placed in removal proceedings?
If they admit to that?
Correct. But it's outside of the 5-year GMC requirements now.
Right, so they would be eligible for NATS, but I would say they're still at risk of being put in removal proceedings for that admission that they did.
And I guess I agree with that. I guess the question is, in general, others' experiences, have they found that they are placed in removal proceedings under those types of circumstances?
Does anyone in the room have experience with that issue? Or on the phone, sorry. I guess I would want to make sure they have some sort of relief from removal before going forward with that.
Okay, thank you.
There's a comment here about that USCIS noted at the last meeting that they did not expect, this is on selective service issues, they did not expect that applications will be rejected if the form is submitted without a status information letter. And Citizenship Committee will be trying to clarify this with National USCIS Liaison prior to Citizenship Day. So yeah, you're always safest to have it, that's for sure, but we'll keep information coming as we get it.
There's also a question from someone on the phone about suggestions or resources for physicians for the disability waivers. Generally, just in my experience, we try to use the person's primary care physician or a specialist that they refer them to. There isn't really a list of physicians who do those. So I would suggest starting with the person's primary care provider.
And then how would a physician know whether it's a disability or not? Is there any place to for guidance?
Well, so the instructions give examples of that, and then as attorneys, I see that sort of as our job to explain the legal standard to them, and then they make the medical determination, and you argue about it. But,
This is Lily. I was just going to add that some of the legal groups that we work with have put together a little cover letter guide for physicians on like FAQs about the disability waiver and sort of just introducing people who maybe have not ever seen an immigration form before to what this is and what it's for. And so if folks wanted to get in touch, you could email Alma and she can put you in touch with me and I can send that to you. I don't know how useful that is.
There's a question here. There was a reference in the slide about derivative citizenship. Will we provide a list? The list, I think we're talking about the grids and the charts, and those are frequently in Kurzban and other sources. And they will be on site at Citizenship Day as well, so you'll be able to use those. I always go to Kurzban for that.
And just quickly, there's still some more time for Q&A, but this is Alma. If you need CLE credit for this presentation, please email your name and your Washington State bar number to alma@rioscruz.com.
okay, are there any additional questions from anyone on the phone? Right, then we'll turn it over to Lily.
Great, thanks everybody. So just a few things as far as logistics for Citizenship Day. Before I jump into the slides, a couple notes that I made regarding like what changes we're going to see at Citizenship Day if you've volunteered before, or if this is your first time volunteering and you're wondering how we're going to accommodate some of the things that have been mentioned about the new form. So one of the things is we will have on site pre-prepared a number of addendums. There are many places in this new form where there's limited space. For example, employers, children, few other ones where they can only list up to 4. And for additional ones, you have to do an additional sheet. So we'll have pre-prepared addendums that you can just easily, has the fields filled in, and you can just easily fill those in if they have more than 4 children. Along with that, we are going to have a sheet that says, essentially, enclosed, please find the N400 for this applicant, A number, etc. Please note that there are handwritten changes on the following pages, so that if there is a barcode versus handwritten issue for someone, there's a cover letter that alerts USCIS to that there are differences for sites where we are completing the forms on the computer, so that will hopefully help mitigate that issue. As noted, we will be hopefully clarifying with USCIS whether selective service status information letters will be required before filing or just needed at the time of interview, and hopefully we'll have a clear answer back to all of our volunteers on the day of Citizenship Day, whether folks can actually just go ahead and file or if they should wait for that letter. Karin, do you have a question?
No, I have a comment. I asked that question again at the CIS liaison meeting, and they were almost 100% sure that you wouldn't have to file it with the application, but they said that they would get back to ALA if they learned otherwise.
Okay, so Karin said that the Seattle office was almost 100% sure that the status information letter would not be required at the time of filing and just be needed at the interview, and that they were going to let us know if that was different, and we haven't heard anything, so we can assume that that's safe to advise clients as citizenship.
For Citizenship Day, to show that there's a process that we go through where if you're participating in that, you are asked to sign your name, if you're in a firm, your firm's name, the full address of your business, and for Citizenship Day you can actually put Iowa CD for Citizenship Day, and then the city in which you're completing that form. But we have been asked to complete that information with our own personal information as well.
Right, and the last new thing on the form, now there is an interpreter statement on page 19 and 20 of the N400, and it says you only need to complete this if you are asking for an exemption from the English requirement or a disability waiver, and you use an interpreter to complete the form. So you wouldn't necessarily need to complete this if you use an interpreter to clarify a couple of questions, or if you don't ask for a disability waiver or an exemption. But that is just another new piece to be aware of on the form. And with that, we'll have Lily come up and talk a little bit about Citizenship Day logistics. But I guess we should just open it up to any questions either on the phone or in the room that people have about eligibility or the new N400. I don't think any of us have been in an interview yet where the new N400 was adjudicated, but we can try to answer questions.
All guests have been unmuted.
The alien smuggling issue.
Okay.
So if an applicant has a young child that they brought in more than 5 years ago, let's say at age 3, and that child's now 12 years old, and the purpose of becoming a citizen is to immediately try to get them LPR status, is the applicant at a huge risk of being placed in removal proceedings?
If they admit to that?
Correct. But it's outside of the 5-year GMC requirements now.
Right, so they would be eligible for NATS, but I would say they're still at risk of being put in removal proceedings for that admission that they did that.
And I guess I agree with that. I guess the question is, in general, others' experiences, have they found that they are placed in removal proceedings under those type of circumstances?
Does anyone in the room have experience with that issue? Or on the phone, sorry. I guess I would want to make sure they have some sort of relief from removal before going forward with that.
Okay, thank you.
There's a comment here about that USCIS noted at the last meeting that they did not expect, this is on selective service issues, they did not expect that applications will be rejected if the form is submitted without a status information letter. And the Citizenship Committee will be trying to clarify this with National USCIS liaison prior to Citizenship Day. So yeah, you're always safest to have it, that's for sure. But we'll keep information coming as we get it.
There's also a question from someone on the phone about suggestions or resources for physicians for the disability waivers. Generally, just in my experience, we try to use the person's primary care physician or a specialist that they've referred them to. There isn't really a list of physicians who do those. So I would suggest starting with the person's primary care provider.
And then how would a physician know whether it's a disability or not? Is there any place that they can go to for guidance?
Well, so the instructions give examples of that, and then as attorneys, I see that sort of as our job to explain the legal standard to them, and then they make the medical determination, and then you argue about it. But yeah.
This is Lily. I was just going to add that some of the legal groups that we work with have put together a little cover letter guide for physicians on like FAQs about the disability waiver and sort of just introducing people who maybe have not ever seen an immigration form before to what this is and what it's for. And so if folks wanted to get in touch, you could email Alma and she can put you in touch with me and I can send that to you. I don't know how useful that is.
Quick announcement about this.
And there was a question here. There was a reference in the slide about derivative citizenship. Will we provide a list? The list, I think we're talking about the grids and the charts, and those are frequently in Kurzban and other sources. And they will be on site at Citizenship Day as well, so you'll be able to use those. I always go to Kurzban and look for that for my purposes.
And just quickly, there's still some more time for Q&A, but this is Alma. If you need CLE credit for this presentation, please email your name and your Washington State bar number to alma@rioscruz.com.
Okay, are there any additional questions from anyone on the phone? All right, then we'll turn it over to Lily.
Great, thanks everybody. So just a few things as far as logistics for Citizenship Day. Before I jump into the slides, a couple notes that I made regarding like what changes we're going to see at Citizenship Day if you've volunteered before, or if this is your first time volunteering and you're wondering how we're going to accommodate some of the things that have been mentioned about the new form. So one of the things is we will have on site pre-prepared a number of addendums. There are many places in this new form where there's limited space. For example, employers, children, a few other ones where they can only list up to 4. And for additional ones, you have to do an additional sheet. So we'll have pre-prepared addendums that you can just easily, has the fields filled in, and you can just easily fill those in if they have more than 4 children. Along with that, we are going to have a sheet that says, essentially, enclosed, please find the N400 for this applicant, A number, etc. Please note that there are handwritten changes on the following pages, so that if there is a barcode versus handwritten issue for someone, there's a cover letter that alerts USCIS to that there are differences for sites where we are completing the forms on the computer, so that will hopefully help mitigate that issue. As noted, we will be hopefully clarifying with USCIS whether selective service status information letters will be required before filing or just needed at the time of interview, and hopefully we'll have a clear answer back to all of our volunteers on the day of Citizenship Day, whether folks can actually just go ahead and file or if they should wait for that letter. Karen, do you have a question?
No, I have a comment. I asked that question again at the CIS liaison meeting, and they were almost 100% sure that you wouldn't have to file it with application, but they said that they would get back to AMA if they learned otherwise.
Okay, so Karen said that The Seattle office was almost 100% sure that the status information letter would not be required at the time of filing and just be needed at the interview, and that they were going to let us know if that was different, and we haven't heard anything, so we can assume that that's safe to advise clients at Citizenship Day, and I'll let everyone know if we hear differently. The final thing to note with Citizenship Day when we talk in depth about good moral character and removal issues is that on-site for all of the different locations, there will be designated people with criminal and immigration experience, known as sort of the criminal or special attorney. So we do want all of our volunteers to be familiar with this material, but folks that don't have experience assessing criminal matters and their implications for immigration, we're not anticipating that you will be the final word on whether the person files. There will be a designated person that can make that determination at Citizenship Day. So I don't want people to think that if you've never done this before, this training prepares you to do that, because we do want you to know the information, but we're not expecting that you're the be-all and end-all decision maker. So a few logistical things as far as Citizenship Day. As you may know, Citizenship Day, the purpose is to help legal permanent residents apply for citizenship. In Washington State, there are an estimated 180,000 legal permanent residents across the state who are eligible to apply for citizenship. They've had their green cards for 3 or 5 years. If we can mute phone people.
All guests have been muted.
Yay! And so, but in a given year, less than 10% of those people actually do apply. And so the goal of Citizenship Day, which was actually started by Paul Soref of AILA many years ago, was to help expand access to citizenship. As you can see, it's a complicated process. It's even more complicated now with this new form. And so we want to make sure that people have access to the legal services that they need. And so One America has been doing this since 2008 in collaboration with AILA. The event on April 26th, it coincides with AILA National Citizenship Day. So we're one of, I think, like 40 or 50 events all across the country that are going to be happening on that same day to expand access to citizenship, and also to coincide with this release of the new form, just kind of a big push for getting people through the process. Of course, we ask all of our volunteers at Citizenship Day to sign a confidentiality agreement. Attorneys are all very familiar with that kind of thing. And then we do just ask that if you are volunteering with us at Citizenship Day, to plan to be flexible. Citizenship Day is kind of a controlled chaos. We plan everything in advance. We plan almost to a fault. And then there's always some last minute thing that comes up. And so we just ask that if you're planning to volunteer at a site and something changes last minute or something like that, that you be as flexible as possible as when you're a volunteer and work with the One America staff that are on site with you. Just a quick rundown of how Citizenship Day works when clients come. We open our doors at 10 a.m. and clients will check in and move through 6 basic stations. There's an intake station with volunteers where they will fill out the intake form, and everyone in the room has the yellow form, that's the actual intake form that the client fills out, and then the front sheet our volunteers fill out. And that's available on the website as well if you want to take a look at the paperwork and ahead of time. If you're volunteering with us in April, I encourage you to do that. After the intake station, they go to the forms preparation station, aka the paralegal station, where paralegals, law students, and attorneys that are not immigration attorneys or who have no experience or little experience with NATs can help people actually fill out the forms. After that, there's an attorney review, that's your role, where you're looking over the form with people, making sure that the form is filled out completely and that all of the legal issues are addressed and resolved, and that the person is good to go forward. There's a second attorney review, that's the quality review. So we do, for quality reasons, we want to make sure that everybody gets to see 2 attorneys when they come in, just so that there's, we're processing a lot of folks through in these big group workshops, and just to make sure that nothing gets missed, we make sure that everyone sees 2 attorneys. Then they stop by a copy station where volunteers will help them print out and or make copies of all the required documents to file, help them put together their packet for filing. It's all ready in an envelope and pre-addressed and everything, so it's essentially all ready to send out at the end. And then we do have an exit station where folks can stop by and get resources in their community. Obviously, Citizenship Day is all over the state, so We put together a list of places where people can go to take ESL classes in their area, where there are citizenship classes in their area. If there are other resources, we put those there as well. So just a quick rundown of what to expect. We do ask that attorneys arrive at 9 at your designated site for a site-specific training, just sort of orientation to what it's going to look like. Doors open at 10, and then we close at 3. We stop accepting clients at 3. And we tell our volunteers to expect to stay until around 5 or 5:30. The one other note with the new form, because we anticipate that it may take a bit longer to fill it out, as you may have guessed, we will be instructing our sort of coordinating site teams to keep track of client flow, and if we have a huge turnout, maybe stop accepting folks a little bit earlier than we normally would. And just, sorry, there's a question. Sorry, I'm reading a question from the chat. Oh, good question. So what I was saying was that we will potentially be stopping our acceptance of clients a little bit early than we have in previous citizenship days to allow for the fact that it's going to take longer. And if that does happen, we can take a wait list and we can go back into a follow-up clinic if there's a large number of people that aren't able to be served. And then I've mentioned many of these changes to accommodate the new form. I don't need to highlight anything except that the first group of clients will generally go straight to the attorneys as soon as they come in and get checked in. And we do sort of an initial evaluation. Are they eligible? Do they have their green card? Do they have their paperwork? Then they'll go straight to the attorneys so that the attorneys aren't sitting there waiting for them to make their way through those first few stations. And then we can get people started a little bit faster. Also, we'll have designated paralegal volunteers to complete fee waiver forms, and we'll be training them on that. The question from the computer was, when there are sites where the forms will be completed on the computer, how do we kind of move people through? So we will be providing USB flash drives to some of the sites, and then some of the sites where we don't have those, we will have a special Dropbox account set up where people can upload a completed application form. So essentially, the person comes, the paralegal helps them fill out the form on the computer. The form is saved in some format, and we will give you an orientation to your specific site, what that format is. It will either be uploaded to Dropbox or it will be saved on a USB. And then the next station, the attorney will also have a laptop. They can open up that person's application, see it right in there, and then they can go ahead and make changes directly electronically. Other sites, specifically the Mount Vernon site, will be doing the application review, the application filling out and review entirely on paper, so that won't be an issue for that site. But the other 3 do have the capacity to do electronic forms completion because we have the computers on site. Yes?
So Lily, just to confirm, we're still going to be doing screening up front, right, for both the criminal and the language as well?
Yes. So the question was, will we be doing some sort of screening up front for criminal issues and for whether people speak enough English to actually be able to file for citizenship or can pass their interview in 3 months or so after they file? And yes, the answer is yes. We will be training our intake volunteers to do screening as to language ability. Essentially, they're going to talk to the client in English, and if the client isn't able to speak back to them in English and they don't qualify for one of the waivers, we will be giving them ESL class information and encouraging them to maybe apply in 6 months after they've brushed up on their English a little bit. As far as the criminal review, on the intake form, you'll notice that we ask a number of questions regarding criminal history, and essentially if anyone has anything above and beyond a traffic violation that they note on that form, that person will be going straight to the special or criminal attorney before they go through the rest of the process, just to be assessed as to whether it's worth them actually staying and filling out the form or not. So we don't want them to spend 3 hours and then find out, oh, you have this conviction and you should wait 3 years anyway. A few reminders, there is a segment of the intake form that is your responsibility as a volunteer to fill out. There's a section for attorney and there's a section for quality review if you happen to be a quality review attorney that lists out all of the steps that we need to make sure that you do with the client. So you just need to check off all the boxes on the first page of the intake sheet that are for your specific role and write your initials. That's our sort of internal quality review system. It's the only way that we know what happened with the client on that day, if there's any follow-up needed, if there was a reason that they were referred out or weren't able to apply. We need to know that information, so it's just really important, and we will be kind of coming back to you to remind you to fill those sections out on that day. We have a designated person called a flow manager, which is the One America staff person. When you are done with the client, you want to check back in or send a volunteer to check in with the flow manager to say, I'm done with this client, now they're ready for quality review, or on quality review, they're done, they need to go make copies. That way we can move them through efficiently, make sure that they go through all the stations, and you'll get oriented to this on site. At the end of the day, all the clients should get a packet from the attorney, from you guys, that says what to do next. We have those pre-prepared, and a completed and signed N400, or a slip that indicates why they're not eligible to file, and you'll have those on site. You can explain to them why they're not eligible. Maybe they need to wait 3 years, maybe they can't file at all. And then I'm gonna sort of breeze through these last few slides. The main thing to take away is that you will have a number of resources on site. You'll have binders with all the documents, the question about derivative citizenship, all those charts are in there, the most commonly needed, pages from CURSBANS, we have copies of those, all of that kind of thing. We do encourage you, if you have a favorite resource like CURSBANS, go ahead and bring it. If you want to bring your own laptop because you love it and you're really familiar with it, bring that too. We will have laptops for some of the sites, but they're not super fancy. But you do have a large number of resources available to you as a volunteer. And there's a designated criminal specialist as well. And one last note, we will have designated paralegals to fill out fee waivers. If you've never looked at a fee waiver or done a fee waiver before, I definitely encourage you to read the instructions, the I-912 instructions, which you can download from USCIS, and the I-912 form. We will ask that if the client has a fee waiver that you glance over that with the client as well. Essentially, we will be filling those out for clients that have household incomes under 150% of the federal poverty level and or receive public benefits. Those are the two eligibility guidelines that we use at Citizenship Day. There's a third one which is called compelling financial need that it's too complicated to do at Citizenship Day, so we just won't do those. And we will only be filling them out if the person has proof of this on that day. So you'll want to familiarize yourself with that form. And then one quick note about that is if you're looking at somebody's public benefits document and you are worried because you see that they started receiving public benefits within the first 5 years of legal permanent residence, I've had a number of attorneys ask me questions about this at Citizenship Day because their client got food stamps within those first 5 years. And within Washington State, that's okay. Legal permanent residents can get food stamps within the first 5, or regardless of their admission date. Federal food benefits are not available to legal permanent residents within the first 5 years, so sometimes that's a red flag for people. But within Washington State, as long as it's state-based food assistance, that's not a problem. But it is a quick check of, the question on the N400, did you ever lie or misrepresent to receive public benefits? If they say no to that, but then there's something really glaring in their, public benefits document, then that's kind of a red flag to you too. It's not something that I've ever seen, but at Citizenship Day, but it's always something that could come up. And then the most important slide, thank you. A huge thank you. We can't do Citizenship Day without our training volunteers. Also, thank you for sticking with us during this long training. My contact information is at the end of the PowerPoint presentation. I'm Lily Hankins again. Feel free to call me with anything. If you have a really, really specific legal question, though, you may want to contact Karen and Megan. They are the co-chairs of the AILA Citizenship Day committee this year. But again, thank you so much. I look forward to working with you, many of you on April 26th, and if not then hopefully at a future Citizenship Day. And feel free to get in touch with me with any questions.
Thank you. Thank you. Thanks, Emily and Greg.